Commonwealth, a petition for writ of actual innocence. Have Mr. Adams and Mr. Robleski and Ms. Stamos. Mr. Adams, you're presenting argument, is that correct?
I will be, Your Honor, and I'm joined at the table by my associate, Sarah Henson.
Good morning.
Good morning. Nice to have you before the court, too.
Thank you.
And Mr. Robleski, are you presenting argument for the Attorney General?
Yes, Your Honor.
All right. As counsel both know, I think each side has 15 minutes. And as petitioner's counsel, would you like to reserve a portion of that, Mr. Adams, for rebuttal?
I would, Your Honor, and I apologize for not standing earlier.
That's all right.
I would like to reserve 4 minutes for rebuttal.
4 minutes?
Yes.
All right. You have it, and you may proceed when you're ready.
Thank you. May it please the court. My name is Attorney Jared Adams, for the record, Jarrett, and I'm here on behalf of the petitioner, Terrence Richardson. I'd first like to begin by thanking this court for allowing me to present on behalf of Mr. Richardson, and I am also here today joined by supporters of Mr. Richardson, including his mother, Annie Westbrook, and I would respectfully request again 4 minutes as rebuttal, and I'll begin. On Saturday, April 25th, 1998, a single shot rang out in a wooded area in the Waverly Village Apartments in Waverly, Virginia. That bullet would go on to tragically take the life of Officer Alan Gibson while in the line of duty. But as this record clearly supports, there were 2 more victims that day. These 2 victims will ultimately also lose their lives, but in a different way. Terrence Richardson, along with co-defendant Ferron Claiborne, were framed for the murder of Alan Gibson, and they have both been in federal prison for the last 25 years. Mr. Richardson is before this court today on an actual innocence petition based on non-biological evidence. And in short, to meet this standard, Mr. Richardson must show that there was new material evidence that was not before the court and that could not be found by diligence, and that it is material and that it would leave no trier of fact finding guilt beyond a reasonable doubt. And to this court, I say to you that these 3 pieces of evidence, the statement of Shaniqua Gay, she was the only eyewitness to this case to see a suspect run away from the scene. There was also other evidence in that Ms. Gay, unbeknownst to everyone, including the community, Ms. Gay was known to the authorities hours after Officer Gibson was found shot. She wasn't taken to a police station. She was taken to the home of a Sussex County sheriff where she was, and no other way to explain, interrogated. This young girl was 11 years old. She had saw Officer Gibson on the ground. She saw a suspect running, and she described the suspect in very good details as a kid would. She said he was a dark, big, ugly man with dreadlocks. This is important because Officer Gibson's dying declaration to a trooper who arrived on scene before he had passed away was that they were wrestling with me. It was a guy with dreadlocks and a ponytail, and the other guy was bald. Had a lower haircut.
Mr. Adams, if I could interrupt for one moment, Judge Fulton. Let me ask you this as it relates to Shaniqua Gay.
Yes.
Wasn't her existence known to the Commonwealth as well as to your client's trial counsel?
Judge, we argue that it was not, in that she was only known by name only. And Judge, if I may go into that a bit.
I thought a subpoena was issued for her.
So, again, Judge, a subpoena was issued for Shaniqua Gay. But the only people who knew what Ms. Gay was going to say was the authorities. Not even the Commonwealth himself, who provided an affidavit, had any knowledge that she had identified another suspect literally hours after the crime had took place. And so the defense attorney, Mr. Boone, at the time, hired an investigator. The investigator couldn't get in touch with the witness at all, and the only thing the investigator could come back with was, well, the authorities investigating this told me that there was a witness that was going to be called and she saw some man running away. They deliberately and intentionally gave her little relevance to the authorities. So there was another point, Judge and Ms. Gay, in that if the court is having a problem believing that diligence could not have found Ms. Gay, the photo lineup was in the complete control of the authorities. They conducted a photo lineup in which Ms. Gay selected the man that she saw running away from the scene. And Judge, it wasn't just a random man. This man's sister lived above the crime scene, and he just so happened to fit the description of having dreadlocks and thick in stature as she described. That photo lineup is evidence that is separate and apart from this statement. It is evidence that was not listed, not turned over to the court at all, and there is no way on earth that anyone through diligence would have been able to find that, even if they did get in contact with Ms.
Mr. Adams, if in fact trial counsel had consulted with Ms. Gay and relates to what her anticipated testimony would have been at trial, would not it have been also due diligence for him to inquire whether or not she had made any identification?
That is true, Your Honor. That is absolutely true, and it may get down to that point. But Judge, again, the police were in complete control of this evidence. This is evidence. It's different from a police report. A photo lineup is evidence that should be turned over, and it is exculpatory because it did not identify Mr. Richardson or Mr. Claiborne. There's also this, Judge, because I want to make sure that I have time to go through all of evidence. The last piece of evidence is as well significant, and it's also corroborating everything else. There was a 911 call that came in onto the tip line into the sheriff's office. That 911 call said that Mr. Richardson and Mr. Claiborne were the wrong people, and the people who are responsible is the person who was named and picked out of the photo lineup. And inexplicably, there is absolutely no complete record of any kind about what type of investigation was done with this man. And I think that this court should also consider this. At what point does the death of an officer not be investigated seriously enough to where everyone mentioned, everyone who could be a viable suspect is brought in and probed? Where is the record of this man who has been identified throughout from the very beginning? There is none. Mr. Richardson and Mr. Claiborne were framed for this murder, and it seems to be an open secret that exists in this town. And I want to make sure that I go on and to tie in all of the evidence that we have, because
Can I
think
ask you on that, Mr. Adams, to follow up on Judge Fulton's question? You mentioned the photo array,
Yes.
and the photo under which the signature Shaniqua Gay is signed. What evidence do we have in the record that she saw that she signed, because that was definitely the individual she saw, and that it's Leonard Newby? Because I think that's your argument, right? That
It
it's
is,
Leonard
Your Honor.
Newby.
Your Honor, we have the copy of the photo lineup that was discovered on the federal level. When this case went to the federal court, there were a bunch of subpoenas that were issued out, and the sheriffs turned over documents. And when those documents were going through, that photo lineup was in those documents. Mysteriously, they can't find the photo lineup now, but the statement was most certainly verified to be in there. And there's also this.
The photo, as you know, what we have,
Yes.
What you sent us, you can't see a face. It's more like a silhouette, basically.
You can, Your Honor, but I'll point this out. There was an interview conducted of the trooper who presented the photo lineup, and that trooper identified who she identified, which was Leonard Newby. That's what caused the authorities to at least make contact in the record with Leonard Newby. That's how his name came up in the first place, and quite frankly, his sister lived right above the crime scene, and she was one of the uncredible witnesses who gave several different versions of events until she ultimately said, oh yeah, it was Terrence and Farron who did it. And I'll go a little bit further on this sister who was made to be a witness. There is evidence in the record that she had made statements to the then sheriff at the time that she was being threatened into making these statements that it was Terrence and Farron. There's also this. In the very first statement that Ms. Newby gave, she identified a man that the authorities went after, and this man was in jail at the time. There is absolutely nothing credible at all in this case that would suggest that these men were guilty. It just so happens that they're in this poor town, their families are getting by the best that they can, and they are terrified that they will be put to death, not because they're guilty, but because they didn't know that the evidence of their innocence was withheld and they didn't have it to be able to prove it.
Can I also ask you, and you noted earlier that, we're bound by the statute, of course, by the actual innocence statute. And the statute talks about this has to be new evidence that wasn't discovered before and couldn't have been in the exercise of diligence, as you know, and you referred to that. We look at the subpoena for Shaniqua Gay. It had 3 other names on there as well, but it had her name. And the clerk notes that it was issued on November 5th, 1999. And the proof of service came back. It was served on her father, I guess because she's a minor. Mm-hmm. She was 9 years old, right?
Yes.
And so it came back, the proof of service, and it shows that was filed in the clerk's office as of November 19th, 1999. And the hearing wasn't until December 8th of 99. And then the sentencing order wasn't until March 8th of 2000. So it was within the trial courts, the circuit courts, the bosom of the court, as they say, until March of 2000. And you had provided us in one of the appendices that you filed with the court, the letter that Mr. Boone had written to your client when your client was expressing his unease about what had happened, that he'd pled guilty. And Mr. Boone, of course, was trial counsel, and he said, if you want me to withdraw it, I'll do it. I don't recommend that, but so forth and so on. So all of that was going on during the time it was still within the bosom of the circuit court. For months, they knew about Shaniqua Gay because it was actually, even if it wasn't in the Commonwealth's attorney's file that was supposedly an open file, right, it was in the circuit court clerk's file. So all they had to do was go to the courthouse, which lawyers usually do, and look in the clerk's file. So help me understand, if you can, why this wouldn't have been a lack of exercise of diligence.
I would say this, Your Honor, and I see that the yellow light is on.
And we've asked you a lot of questions, so I'll give you some extra time.
This is the best answer that I would have for that. This is a capital murder case. The attorney hired an investigator. The investigator is providing reports about what's going on in real time. The only mention of this young lady was that she saw someone running from the scene. That does not say whether it's inculpatory or exculpatory at all. And if she doesn't have a good identification or a bad identification, it could hurt a case. And I'm just only assuming all of this is going on at the time. I do know this. With that letter that Your Honor mentioned, in that letter, Mr. Boone is explaining to Mr. Richardson why he doesn't have a defense. And he's basically telling Mr. Richardson, look, you don't have a defense, you need to keep your guilty plea. If there was any idea about this witness being material and critical to this case, he would have most certainly have stopped what he was doing to address that issue in that letter, and it wasn't done. I believe that the best answer to the court on diligence is this. How can diligence overcome police corruption, police misconduct, when even the Commonwealth himself has said that he never had any idea or inkling that there was another suspect identified? I think that diligence is well vetted in that the Commonwealth subpoenaed this witness, and he provided an affidavit saying that even though he subpoenaed her, he had no idea that she had identified someone else. This subpoena, I believe, was sent out because when you're doing a capital case, it looks like it's going to trial. They want to make sure they have witnesses, even if they don't use the witnesses. But no one knew that she had already identified someone. And I think that this has to be considered, that diligence is one thing, where a lawyer could have, but in this case, who would think that this lawyer would not call and interview her if they had turned over the evidence that was readily there and that they had gotten hours after Mr. Gibson was shot? It just simply, I would also say, although The new evidence that we are arguing is the statement, the 911, the photo lineup. I think the strongest piece of evidence is the fact that these men were found not guilty in a federal court with the same evidence and without the use of Ms. Gay, because even then they had no idea that she existed. And to couple that, why would a Commonwealth agree to a plea deal like this? Why would a Commonwealth, who was taking so much heat at the time that David Chappelle was down here doing his case, not run to defend himself and say, look, we had another viable suspect and we're after this guy right now? Why? And with that, Your Honor, I'll rest and save time for my rebuttal.
Thank you, Mr. Adams. Mr. Robleski.
Good morning, Your Honors, and may it please the Court. My name is Brandon Robleski, and along with co-counsel Theo Stamos from the Attorney General's Office, I represent the Commonwealth. The Commonwealth argues today that Mr. Richardson has failed to prove that his evidence is newly discovered or material, or that no rational fact finder would convict. So I plan to address 2 points today. First, the substance of the questions that have been asked by the Court regarding the materiality and diligence invoked in this case, as well as the substance and effect of Mr. Richardson's guilty plea. But first, to briefly state the case from the Commonwealth's perspective, Mr. Richardson is asking the Court today to ignore his presumptively valid guilty plea and instead consider the assumed historical and factual accuracy of statements allegedly made by a 9-year-old child who was a Commonwealth's witness against Terrence Richardson in 1999 and who cannot be located in the present day. Judge Fulton, first to your question, where you asked Mr. Adams if Shaniqua Gay had been known to trial counsel back in 1999. The record is absolutely clear that she was. Mr. Boone, the trial defense attorney, was independently interviewed by the Office of the Attorney General, and he was able to not only identify Shaniqua Gay by name, but say the prosecutor had told him about who Shaniqua Gay was and what she might testify to. Getting to one of your subsequent questions to Mr. Adams, of course, that Mr. Boone, the trial counsel's knowledge of Shaniqua Gay cascades to Leonard Newby, assuming that Shaniqua Gay did indeed identify Leonard Newby, which there is no evidence in this record that Shaniqua Gay named Leonard Newby. There's no evidence that Leonard Newby is in the photo lineup. There's no evidence that Leonard Newby is in the handwritten statement, or what Mr. Adams refers to as the Gay statement.
Can you elaborate on Mr. Adams' point that he just made to the Court, that the officer who did the photo array, and I guess was with Shaniqua Gay, when she signed her name under that one photo, that
right.
We really can't see anything but a silhouette, but we can see that the officer said that was Leonard Newby.
Your Honor, I am drawing a blank on where in the record that specific information is contained, but what the record does indicate is that multiple officers who were alleged to have been present for these photo lineups gave markedly inconsistent statements about whether they were even there for the photo lineup. I don't think we have a firm indication in this record as to whether one of the officers, I wouldn't be able to give the Court a name, said that Shaniqua Gay did identify Leonard Newby. And as Your Honor mentioned, the photo array is not even a traditional photo array. It appears to be, at most, an identification of hairstyles. The faces are blacked out. We don't know who these people are. We don't know why the photo array was compiled. We don't know whether it means that a suspect was identified or a hairstyle similar to somebody the person had previously seen was identified. The only thing we know for certain about the photo array is that a person identified something about another person for some reason. That's all we know about the photo array, Your Honor.
Commonwealth's attorney here had an open file policy.
Yes.
Right? And Mr. Boone has said Mr. Chappell was very good about sharing information. Mr. Chappell said, well, we had a discovery conference even where we'd sit down and exchange information. Where was the photo array? Does the record tell us anything about where the photo array and Shaniqua Gay's statement were?
The record is completely silent as to whether those items were indeed in the discovery conference. Not only silent as to whether they were affirmatively included, but as to whether they were not there. Because the affidavits from trial counsel simply say, upon the best of my recollection, I don't recall if these items were there. These attorneys were both very candid with the Court. They both were recalling things from memory. They did not have access to their trial files. And because this was an open file case, we don't have a statement filed with the Circuit Court clerk as to what items were disclosed in discovery. Common practice for certainly a murder case for a prosecutor would be to file an itemized list of items. When I was a prosecutor, I would follow the same practice. So having an open file policy for a capital murder case is certainly a bit unusual. It's not inappropriate or illegal in any way, but it renders Mr. Richardson unable to satisfy the court that these items are, at a base level, unknown or unavailable, because the best recollection of counsel about whether they remember 9 documents out of thousands, 23 years and thousands of cases and clients later, simply is not proof by the preponderance of the evidence that these items were unknown or unavailable.
Mr. Wroblewski, could you address Mr. Adams' argument that what we have here, the situation where the local sheriff's office essentially botched this investigation, not only that, but that they withheld evidence?
Your Honor, I don't think that there is evidence of withholding of evidence or prosecutorial or police misconduct that's on this record. Even if there were, the court cannot consider those legal claims in the actual innocence context. As I noted in my brief, the killing of a police officer in this small town set off a firestorm. It set off a lot of rumors. The Commonwealth will certainly not contest that there were a lot of irregularities in the investigation. But Terrence Richardson was not forced to plead guilty. He was not forced to admit that he was the man with dreads who shot who shot Officer Gibson. But he did, and that's what his guilty plea to involuntary manslaughter meant. It meant that he admitted to all of the incriminating elements and facts for involuntary manslaughter, which includes the crucial element of identification. So the strong, unrebutted legal presumption that Mr. Richardson's guilty plea is valid has not been overcome here, I would submit. So when he pled guilty, he admitted that he was the man with dreads who shot and killed Officer Alan Gibson. His guilty plea was also an admission that he threatened to harm the Commonwealth's material witness, Sean Wooden, because Richardson had confessed to Sean Wooden that he shot and killed Officer Gibson. And Mr. Wooden maintains his testimony against Richardson, as the court can see it in his subsequent interview, even after being threatened, even after being admonished and called a liar.
He originally said he pointed at Leonard Newby, but from the preliminary hearing testimony on, he's been consistent that it was Mr. Richardson. Is that right?
Correct, Your Honor. And the Commonwealth is certainly not glossing over the fact that Leonard Newby did change his testimony, but that was known to Mr. Richardson. Mr. Richardson knew
Leonard Newby, or you mean
Mr. Wooden?
I apologize. I mean Sean Wooden. Thank you, Your Honors. Mr. Richardson knew that there was an inconsistency in Sean Wooden's testimony. He was not forced to accept that as the Commonwealth's evidence, yet that's exactly what he did when he pled guilty. And so that is the evidence that I argue continues to establish the validity of his guilty plea. That, along with everything else that was proffered by the Commonwealth, which is quite similar to the lengthy factual proffer the court recently noted in Parson, established a firm presumption of the continuing validity of the guilty plea, or rather the conviction. Your Honors, in conclusion, the evidence that Mr. Richardson has brought forward today, it falls far short of that which the court has granted the writ upon in the past. So, for example, Mr. Copeland, who was convicted of possession of firearm by felon, his firearm was determined after subsequent analysis by the Department of Forensic Science not to meet the common law definition of a firearm. Mr. Montgomery's alleged victim was convicted of perjury for lying at Montgomery's trial. And Mr. Watford's victim was excluded, or the probability of his presence on her sample was dramatically reduced, and Mr. Watford's victim testified that she never saw him on the day of the offense. That is the type of incontrovertible evidence an actual innocence petitioner has to offer. But in contrast, what we have here is the assumed historical and factual accuracy of the statements of a 9-year-old child who was a Commonwealth witness testifying against Terrence Richardson in 1999 and who cannot be located in the present day. And I think what is most fatal to the petition here is that Mr. Richardson is attempting to dismiss his presumptively valid guilty plea. And he cannot even raise a rebuttal to the compelling implication the court recently noted in Parson, which is the question of whether he lied at his guilty plea colloquy in 1999. So I would submit that faced with this evidence of Mr. Richardson's self-interested prevarication, any rational fact finder would reject the new claims and again convict Mr. Richardson of involuntary manslaughter. I submit that Mr. Richardson has failed to prove by the preponderance of the evidence that no rational fact finder would convict. If there are no other questions, I would rest on my brief.
Let me just ask, I need to ask you about, the fact that the Commonwealth has changed its position in this case.
Yes, Your Honor.
Obviously, this is a matter of original jurisdiction before the court, and today is the first time we've had oral argument in this case, but as far as a petition for a writ of actual innocence. But the Commonwealth, as they say, the Commonwealth is the Commonwealth is the Commonwealth. And so can you address why the Commonwealth, why the Attorney General felt that despite what was filed back last November, needed to essentially change its position in this case?
Yes, Your Honor. Well, first and foremost, the Constitution and the Code empower one official to execute the legal policy of the Commonwealth in its courts, and that is the elected Attorney General. So I am here to advise the Court what the position of the elected Attorney General is in this case. The legal policy of the Commonwealth of Virginia, it cannot be set by former elected officials. It can be adopted if it's accurate, but just as the Court does not accept concessions of law from the Attorney General when the Attorney General concedes the writ, I don't think the Court is obligated to accept concessions of admissibility of evidence or of legal elements. So to the extent that the previous brief argued erroneous factual and legal positions, which is the Commonwealth's position here, the Court is not required to adopt those or consider them. That's why the Commonwealth not only filed its position change letter indicating to the Court exactly how and why it sought to change its positions, but also moved for leave to file a supplemental brief. If the Court did not wish to hear the Commonwealth's new arguments, the Court certainly could have denied that motion, but the Court did grant it, and we're thankful that the Court did. So for those reasons, Your Honor, the Attorney General, I believe, was well within its rights to change the Commonwealth's position in this case, would ask the Court to adopt the Commonwealth's position and dismiss this petition.
Mr. Wroblewski, let me ask you this as it relates to the acquittal in federal court. Would you address Mr. Adams' argument in terms of how this court should view that acquittal as it relates to his guilty plea to the involuntary manslaughter?
Yes, Your Honor. Thank you. Mr. Richardson's acquittal in federal court does not command the same result in this case. A separate verdict in a separate court is not and can never be evidence in an actual innocence case. And that's by the application of In re Rhodes and Waller v. Commonwealth, which I cited in my brief, standing for the proposition that the retroactive application of decisions of law is prohibited in actual innocence cases. The original jurisdiction rules are simply different than the rules the court faces in its appellate jurisdiction. So the same principle that the Court articulated in Waller and Rhodes would apply to exclude the federal verdicts from consideration here. Does that answer the Court's question?
Well, I'm wondering, let's say, for example, in federal court they had tried him on a theory that involved an accidental killing of this police officer.
Your Honor, even if the same ultimate issues of fact were at play, the separate decision of a separate fact finder would still not be evidence in an actual innocence case. I think it involves, first of all, ultimate issues of fact that we would have to essentially suspend the rules of evidence to allow consideration of in Virginia courts. But also, it's just simply the effect of the verdict being cited purely for its legal effect, consequence, or interpretation, which it goes to the definition of a fact. A fact is an actual or alleged event or circumstance as distinguished from its legal effect, consequence, or interpretation. And the federal verdicts are being cited here purely for their legal effect, consequence, or interpretation.
Well, let's say this panel didn't agree with your analysis, and we would find that in this case, if there had been a situation where he had been tried in federal court on the identical charge that they were acquitted in state court, what would be your next argument?
Your Honor, I would, if the court had... So, as I understand the Court's question, if Mr. Richardson had been acquitted of involuntary manslaughter in a federal court, Your Honor, I would still submit that it is the jury's opinion as to the ultimate issues of fact. And the evidence, as the Court will note from the record, was not the same in the federal case. There were different witnesses. There were different items of evidence. There were different testimonies. There were simply different facts brought before the Court. So I would submit that even if Mr. Richardson had been tried for the same crime in federal court, Waller and Rhodes still operate to prohibit its effect from being considered here.
Can I follow up on that, though, because, I mean, you do have, in this situation, the officer, as he's lying there on the ground, making statements about, and he indicated as part of that, didn't he, then we have testimony that they struggled, and he said, there was a struggle, and I got shot with my own gun.
Yes.
And making it sound potentially as if it was an accidental as opposed to an intentional shooting. Obviously, the elements for involuntary manslaughter, it's an accidental killing.
Yes.
He pled guilty to that, have a conviction of that in federal court. He was... the theory was it was an intentional killing, though, right?
Yes, Your Honor.
The prosecution was for an intentional killing. So the elements of the crimes are significantly different.
They are, Your Honor, and I think there's a basis for the jury in the federal court finding what they did. The jury in the federal trial was presented with the state guilty plea to involuntary manslaughter. So it's perfectly possible that the jury in the federal case simply did not believe the United States government's evidence rose above the involuntary manslaughter level that the state had pled him guilty to. So I would say the acquittals are of no moment here, even if they are evidence, which the Commonwealth maintains they are not, because they deal with different elements. The federal jury was not asked to consider the crime of involuntary manslaughter. The federal jury did not implicitly acquit Terrence Richardson of involuntary manslaughter. They addressed only the crime of murder. So the federal verdicts are inapplicable to this case, but even if they were, the Fourth Circuit found that there was clear and convincing evidence to believe that Richardson committed murder, and the Fourth Circuit found that Richardson was reasonably accurately described by Officer Gibson as his killer. So for those reasons, Your Honors, we do ask the Court to dismiss the petition.
Thank you, Mr. Robleski. Mr. Adams, let's see. It says you have 15 seconds. I'm going to go ahead and give you your full 4 minutes of rebuttal.
Thank you, Your Honor.
We had a lot of questions.
Mr. Adams, I'm going to jump in before you get started with your rebuttal and ask if you would address for me, if you would please, the significance of your client's guilty plea.
So, Judge, I'm glad you asked, because that was where I was going to pick up at. I want to use this in the lens of Parsons, which was recently decided by this court. In Parsons, the evidence in Parsons of the new evidence claim was an affidavit of a co-defendant. That affidavit, that co-defendant, was all known at the time, and he was available to be investigated, to make the statement, to make the claim. That's one thing in terms of Parsons. But I think that this court got it absolutely right in Parsons in that it's not even close to this argument in this case. Parsons, there were several different pieces of evidence that placed him in and at the scene of the crime when it was committed. Cell phone records, he was even, stopped while fleeing the scene with a gun. He was there. Mr. Richardson was not there. And in pleading guilty, this court also addressed this guilty plea where it stated, we note that an individual's decision to enter a guilty plea may be influenced by many different factors, and we are not establishing an inflexible rule as to how a rational fact finder would interpret a defendant's guilty plea in the factual situation. I think that statement by the court clearly explains and helps to understand that Mr. Richardson's guilty plea was not because he was guilty. He didn't want to be put to death. He didn't want to be sentenced to life. And had Mr. Richardson had any clue that there was an identification of another suspect that was corroborated by several pieces of evidence, including the fact that the police misconduct, they withheld it, there's no way he would have pled guilty, there's no way a court would have accepted a guilty plea, and there's no way that an experienced defense attorney like Mr. Boone would have advised his client to plead guilty and also write a detailed letter explaining to his client that he had no defense. If that answers your Honor your question,
thank you.
I want to make sure that I don't miss this. No Virginia court has ever allowed a party, even the Commonwealth, to switch positions in the middle of litigation. And what this current Commonwealth has done was in the beginning mislead the court to believe in its letter that there was some new evidence that wasn't presented by the Commonwealth before it, because there was a bunch of documents that just needed to be looked through. Then they made a filing, and they disguised it as a supplemental filing. If it was a supplement, it would have strengthened the position that the previous Commonwealth argued, which is that this court should grant his actual innocence, and if not, they should at least grant an evidentiary hearing. It was a complete reverse course. That's what it was. This court allowed the Commonwealth to submit the filing, but it never said that it was going to take it into consideration, and we never responded because the law is clear. And the Commonwealth never cited any law in making this supplement. I also want to touch, before I go...
Can I ask you on that, Mr. Adams, because if you had said to the court, I gave you some information that I think was wrong, either on a legal explanation or on a factual explanation, we would have let you supplement and correct. This is a matter, it's not on appeal, as you well know. This is a matter of original jurisdiction. It's one of the few situations where our court actually hears something as a court of original jurisdiction. So in the process, just as in many situations in a trial court where there's original jurisdiction, parties end up needing to, as the matter is litigated, change certain things they've told the court. So why isn't that what happened here?
Well, Judge, you're absolutely correct. We, as officers of a court, owe a duty to make sure that we're getting it right, but not everything being reversed. And that is something that the court has to consider. If there was something about evidence that was missed, that's one thing. They literally reversed course on every conclusion in less than 3 weeks. The Commonwealth, before this current Commonwealth, spent 9 months. It requested extension after extension, and we agreed with them so they could make sure that they got it right, and they got it right, Your Honor. They got it right. They were initially charged with capital murder. This court is well aware that when people plead guilty, they do that in exchange for lesser crimes, but their argument has always been consistent throughout the Commonwealth and also the federal trial. They were not there. They did not do it. And I want to make sure I say this again in terms of this new evidence. If this court is going to view the diligence in this case, it has to view it with including the withheld statement, the photo lineup, and a 911 call. It's one thing for the Commonwealth and for the defense attorney to know that a witness is going to be called. But that statement, when it was taken, when it was initialed by the sheriff officer, that became a piece of demonstrative evidence that should have been turned over and would have been in that open file. I'll lastly say this. Now, this case has been so long, 25 years has passed, but there is real-time documents and statements that were made by the Commonwealth and also the defense attorney that clearly show they had no idea about this identification of another suspect. And that is hugely important to consider to this court. They didn't know. And I would like to think this. This isn't just a normal murder. This is a murder of a white police officer by 2 African-American men. And I would like to think that both the attorney, the defense attorney, and the Commonwealth would have not ignored the identification of another suspect. Because what this says to the court is this. If, in fact, Mr. Richardson and Mr. Claiborne are innocent, then someone who killed a police officer has gotten away scot-free. And that should terrify this court and also the Commonwealth as well. I respectfully close by saying this to this court again. I am so thankful that you allowed me on Pro Hoc to appear on behalf of Mr. Richardson. I ask that if you have any reservations, that this go down for an evidentiary hearing. But I argue that there is no need. There was a federally paneled jury who decided that they were not guilty of this murder. And that in itself is clear that no trier of fact, faced with the evidence, and not even including the evidence pointing to another suspect, would have not found guilt. I thank you guys again. I thank your honors again. I'm sorry.
Thank you, Mr. Adams. Thank you, Mr. Robleski. The case is submitted.